Been spending most our lives living in a gangster's paradise. Been spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise.
3, 2, 1, roll 5.
In the name of God, the compassionate, the merciful. Good evening, friends, and welcome to the 6th episode of Crime and Punishment. This is a legal podcast, not a political one. This is the podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida. And with me tonight is my good friend Tiger Gin. How you doing, Tiger?
Good.
Good. So, for those of you who were here last week, you know that we discussed Amendments 1 through 4. We were supposed to discuss the whole Bill of Rights. We only got through number 4 because there's a lot to discuss, especially in the 4th Amendment. And for those of you who were not with us last week, well, we discussed Amendments 1 through 4 of the Bill of Rights. So, tonight we've got 6 through 10 on the table. I also think it's unavoidable to talk about the 14th Amendment when talking about the federal Constitution these days. So let's just, I guess we don't need to recap. Y'all can go back and listen to the last episode if you want to hear about the 4th Amendment. Let's just start off with Amendment 5, unless we have any announcements today. We don't have any announcements, right? Any
Nothing that I know of.
News story. What is going on with Gab? Is Gab shut down? Did the hack, was that like...
periodically just goes down like that. I don't know. I've been messing with it all day too.
Yeah, I think, from what I understand, it got hacked. And they're literally holding it ransom for Bitcoin. So,
oh, that's interesting. That's fun news.
It is fun news. I wish I knew more about it.
Yeah,
but,
I've heard.
Yeah, well, if you... people who hacked Gab and are holding it ransom, if you need a lawyer, you know who to call. So the 5th Amendment. No person shall be held to answer for a capital or otherwise unjust compensation. Now, OBS disconnected while I was saying that. Hopefully you all heard that. But there are several different clauses in here. Several different parts of the 5th Amendment that have been discussed to death in court cases throughout American history. Perhaps the most important one is this phrase, nor shall be compelled in any criminal case to be a witness against himself. Actually, that might not be as important as the next one, nor be deprived of life, liberty, or property without due process of law. And there's also the nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So let's start with that, the easiest one, right? Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That's the double jeopardy clause, right? So if you get taken to trial and you are proved not guilty, the state fails to meet their burden of proof to prove you guilty. They can't do it all over again. So there are some misunderstandings about double jeopardy and what it means. If you go to trial and you have a hung jury, it doesn't really count. You weren't found not guilty. If, however, you go to trial and you were found to be not guilty, then they can't put you on trial for the same thing. I was going to discuss a movie, but that would be a spoiler alert. But let's say a jury attaches. That's really when double jeopardy comes into play. So if you're charged with a crime and it is dismissed, right, before any trial ever even is considered happening, they dismiss the case, and then, a year later they bring it back and charge you all over again. You can't say, well, double jeopardy. Double jeopardy actually attaches after the jury is sworn in. So technically, they could go all the way up to bringing you to trial and then getting the jury interviewed, selecting a jury, and before they're sworn in, they dismiss the case. And then they could bring it back later. Now that would be outrageous conduct, I think, in most cases. Any case I can think of off the top of my head. But that would be when double jeopardy attaches. It's also not double jeopardy. Some people seem to think that, a civil suit and a criminal suit, you can't have both of those because it's double jeopardy. Or, you can't litigate the same thing in family court and criminal court, or family court and civil court, or civil, family, and criminal court. Of course you can. Famously, one of the most well-known cases in American history, the O.J. Simpson case, guy was found not guilty in criminal court, and then they sued him for wrongful death, the families. And they won. That's not double jeopardy. It's a civil action. It doesn't count as double jeopardy. Because you are not put in jeopardy of life or limb, right? These dogs, man. Nor shall be compelled in any criminal case to be a witness against himself. So this is your right against self-incrimination. And you know what? Go watch The People vs. O.J. Simpson. That is an excellent Netflix program. I know we don't like Netflix around here, but you should make an exception for that show. So when you are arrested and cops start asking you questions, this is what Tiger and I always tell you. Don't talk to them. Do not answer those questions. All you say is, I want to talk to my lawyer. Or, I'm exercising my right to remain silent, or I invoke the Fifth Amendment, however you want to phrase it. Don't talk to them. That right to the lawyer is actually the next one, Amendment 6. But you have the right not to say a word to the police, no matter what. And it is difficult to think of instances where you should tell the police your side of the story, especially if you're there in handcuffs. All right? So here's one thing that people find confusing about this Fifth Amendment. And that's the custody or seizure issue, right? So cop walks up to you, starts talking to you. You start talking to him. You incriminate yourself. Well, Fifth Amendment doesn't really apply there. You can't go to court after he's arrested you and say, well, he didn't tell me about my Fifth Amendment rights. You were free to leave, and that's really the crucial issue. You were free to walk away. You were not being detained. You were not seized. You were not in custody. You could have walked away. You didn't have to talk to the cops. But you did anyway. Loose lips sink ships. Fifth Amendment is not going to bail you out of that one. If, however, cops walk up to you, put handcuffs on you, and then start talking to you, well, obviously, now you're not free to leave. Now you can't leave, right? So, at that point, that right of the Fifth Amendment not to incriminate yourself, that applies. You don't have to say a word to them after that. You don't have to ever say a word to the police. That's the beauty of American law. You don't have to say anything to any cop ever, right? Now, if they come up and they ask you for your driver's license, yeah, I guess if they pull you over, but you don't have to say a word to them. You have to talk to them. You don't have to incriminate yourself. But the Fifth Amendment only applies when you are actually being detained, right? So if a cop pulls up next to you on the road, right, does that count as being detained? Like, a cop pulls up to you, you roll down your window, he starts talking. You didn't get pulled over. Lights aren't on. You're not being detained. You're perfectly free to drive away. That actually happened to me. This is a true story. I'm going to tell this story because these people, we're suing them next month, for everything that's happened. So it's going to be biblical. In the meantime, so check this out. I'm with my ex-wife at a Publix, which is a grocery store we have down here in the South. At Publix, go in, get milk, come back out, back the car up. I drive toward the stop sign. And this guy just completely cuts me off. He turns left into the lane that I'm in, cuts my car off. And I see the guy, I'm thinking, this guy is clearly an immigrant. He does not know how to drive his car. Like, that must be what's going on here. Because then he rolls down his window and asks me to roll down my window. So I roll down the window like, all right, whatever. Maybe the guy's lost or something. And the guy tells me, you were speeding. Now I'm in a parking lot, full of people, mind you. Cars everywhere. Like, it's a busy Sunday here. And I started laughing. I was like, that's obviously the most ridiculous thing I've ever said. I started laughing. I said, I absolutely was not speeding. And my ex-wife told me, just go. Just don't pay attention to him. So I did. I just took my foot off the brake and started going forward. And he said, I'm a police officer, sir. What a douchebag. What a total... Is that okay for a family show? Can you say the D word? What a tool. What an absolute tool. Cops, man, can be the absolute most despicable people on the planet. You cut somebody off at a grocery store, accuse them of... And we know where this guy was from. So anyway, I ended up stopping and then leaving again because I'm not detained, not under arrest. He has absolutely no right to stop me. So you don't have to say a word. I could have gotten into an argument with him, told him what an idiot he was, told him whatever I wanted to tell him because you have free speech. But like we said in the first episode here of the Bill of Rights stuff, your free speech only goes so far. You have free speech, but you will suffer the consequences when some uppity cop gets out of line, right? And decides he's going to arrest you whether you broke the law or not. Which, trust me, I have personal experience in will happen. Can and will. So, better to just not talk to them. You don't have to talk to them. If you are detained, you are seized, you are put in handcuffs, or if, 3 cops come up to you all in uniform with guns on them and badges, and it's clear they are police officers, and you feel, I really can't leave right now, or I might get shot, or chased after, or arrested, then you have been seized. You have to, of course, later prove that to the court that you had a reasonable belief that you had been seized. But yeah, once it's clear that you're not allowed to leave, Fifth Amendment attaches. Don't say anything, say lawyer. I want to talk to my lawyer. And here's another thing that gets people jammed up. It's just like that old urban legend, well, if I ask him he's a cop, he's got to tell me he's a cop, otherwise it's entrapment, right? Don't do that. I mean, I know the people listening to this show don't buy drugs on the street, but don't do that. Because that's not true. Cops are allowed to lie to you, right? I forgot what I was even saying about that. The urban legend thing. Well, anyway, if you get seized, don't say anything. I'll probably remember what I was going to say later. Nor deprived of life, liberty, or property without due process of law. Tiger, have I lost you again today? You've been awfully quiet today.
No, you're covering it pretty well.
All right, radical man. Well, let me know if I'm missing anything. There was something I just completely forgot about the compelled in any criminal case to be a witness against himself. I don't know.
Well, before you move on from that, I mean, that also is relevant to court procedure. So if you don't want to testify, you don't have to testify. Nobody can force you to testify. So that's another right that you have, the right to not take the stand.
Yeah, we had someone ask about that an episode or two ago. About testifying in your own case. And as we pointed out back then, for those of you who were not in that episode, it's a case-by-case basis, right? You don't always want to testify. And it's not even because you're guilty. Sometimes you don't want to testify just because you're a really bad witness. Like there are some people who get up there and they're charismatic and they win over the jury and they could be lying through their teeth, right? And then you get somebody who's genuinely innocent go up there, terrible at public speaking, just looks guilty, sounds guilty. And the lawyers advise him, look, man, this person testifying against you is going to look great, and you are not going to look great, and I'm worried about that. And that, again, it's a case-by-case basis. So as up in arms as you might be about your case and you want to get up there and testify and tell your side of the story, that might not always be the best idea. And that's what this Fifth Amendment is about. Nobody can force you to get up on that stand and answer any bloody questions at all. You don't have to do that. You have the option to testify or not to testify on your own behalf. And another thing that people, I don't know, they get jammed up on it. I don't know if they just didn't learn about it, or if their lawyer genuinely lied to them, or if they misunderstood something. But it's your call, right? Your lawyer does not make that decision. Now, your lawyer has to advise you on the best strategy. Your lawyer has to do what's in your best interest. But at the end of the day, when it comes to whether you are going to testify in your own trial or not, it's not up to your lawyer. No matter what they say, it is up to you. So if you want to go against the advice of your lawyer, if your lawyer is saying, look, you're a terrible witness, this person accusing you is an awesome witness, they're not going to believe you, don't do it. Or like in that movie Brian Banks we talked about, right? Where his lawyer straight up told him, you're a black kid, this is a white jury in Los Angeles, all they know is a black kid's accused of rape, like just take the plea. It could be a situation like that. You're a black kid, these guys are all white, don't testify. Or you're a white kid in Charlottesville, don't testify. Like really, it's up to you in the end. If you want to roll those dice and you want to tell the jury your side of the story against the advice of your lawyer, it's your constitutional right to do that or not to do that. So hang on to that right. What else do we have here? Due process of law. Boy, that is a big phrase there. Tiger,
I don't even know where to begin.
Yeah, I don't know where to begin. Why don't you think of where to begin while I quiet these dogs down?
Well, what I did want to go through before we move on, I wanted to interrupt you again about the right to remain silent, is that there are some recent Supreme Court cases saying that if you are literally silent, you're not saying a word to the police, that is not invoking that privilege, it is not invoking that right. Rather, you need to make an unambiguous statement asserting your right to remain silent. So typically that's going to look like you saying, I am invoking my right to remain silent. That's how the courts want to hear it in order for you to invoke that right. So,
true.
It's an odd thing. I don't entirely agree with it, with those rulings, but that's what the courts say.
Yeah, that's a good point. You don't want to just sit there and be quiet because they're going to just assume, that your silence is an admission.
Or they'll
That's
say
happened
you're being
before.
non-compliant, and
Oh yeah, they
and
love
maybe
that
they
one.
might have to invoke some pain compliance, and to make you do something. Yeah, it's you don't want to just sit there and pretend to be a mute.
Yeah, you know how many cases there are where the person is charged with absolutely nothing except resisting arrest? That's just the most amazing thing to me. Like, they can absolutely not commit any crime at all and then get a resisting arrest charge. It's a little tangential, but things like that are just incredible. Like, we give cops such amazing latitude to do whatever they want, so that if you don't comply or whatever, they can charge you with resisting. And if you don't answer them, they can say, well, that's an admission. So yeah, this is why it's so important to know your rights. This is why it's so important to know you've got to say lawyer as soon as they try questioning you. That's due process. All right, did you think of where we want to start on due process? Basically, it just means that they can't take it without legal process. I mean, it's just, I don't know, so many subdivisions that I'm tempted to just move it. Just leave it on. In any event...
Typically they'll look at due process as like, there's either literally process, you're going through the court system, you're going, in the police context, you're going through the booking and everything. And then there's substantive due process, and which invokes a whole bunch of other things. But I believe for the Fifth Amendment, it's typically you're looking at a literal legal process.
Yeah, well, there's substantive and procedural. And procedural is the one everybody wants to talk about. It's, you can't deprive someone of life, liberty, or property without due process, without, going through the motions, basically, without taking them to a hearing, taking them to court, without giving them notice of a hearing, for instance. Like, you can't just drag somebody to court and say, all right, we're here to hear the state's motion on, why you should have your, detention extended, or whatever it could be. Because if you don't have notice of that hearing, you can't respond to it. Obviously, you have to have notice in order to prepare for the hearing. So if you were to make somebody show up to an important hearing like that and they didn't even know about the hearing or when it was going to be, that would be a violation of due process. Basically, anything that goes wrong in court, this is a blanket statement, legal disclaimer, blanket statements are always wrong in the law, because the correct answer in the law is always, it depends. But as a blanket statement, if you think something has gone wrong in court, it's probably due process. I'd say that's probably fair to say. If, I don't know, somebody, shows up and does something stupid, I don't know, man. Anyway, the Sixth Amendment is also super important. Just talk, if you think there's a due process issue in your case, maybe just talk to your lawyer, because there's just a lot of things about it that's not constructive to go into details. Anyway, the Sixth Amendment is also a very important one for a couple reasons, right? In all criminal prosecutions, my God, we're already at half an hour. We're going to finish this tonight, my God.
I was going to complain that you skipped eminent domain, but
no,
let's go to the Sixth Amendment.
We're moving on. If any of you have property, real estate, and you're worried about eminent domain, call an eminent domain lawyer or contact me. I know a good one in Orlando. But we're moving on to the Sixth Amendment, because we're going to spend a month just on the Bill of Rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Now this, much like the Fifth Amendment, we would spend another half hour just on this. It has many subdivisions in it. So let's just take the last one.
First of all, none of this applies during flu season. So just to be clear, that's what the courts are ruling right now. None of this applies during flu season.
That's right. Every case I've heard of one case being dismissed for violation of speedy trial rights during COVID, and that was a state-level case in Michigan. So yeah, every court in the country has said there is no right to a speedy trial when you have COVID around. But let's talk about...
Even the public trial rights are being closed. They're closing down courts, like, oh, you can't go in there or anything, all because of COVID.
That actually violates several parts of the Sixth Amendment when you talk about that. Not just the speedy trial, where everybody in the country is being shut down because of this pandemic, and they can't get into trial. Their trials are delayed by a year, right? Not just that, though. Like Tiger's saying, to be confronted with the witnesses against him. There are there are courts all over the country that are flirting with this idea of doing virtual trials.
Not flirting, they're doing it.
I know. I'm trying to. I still want to believe it's. I guess I'm in the denial phase. I want to believe that it's flirting, that they've done this and they've realized the error of their ways and they're never going to do it again because it was terrible. Just
think a lot would learn. I mean,
you would think
Zoom trials. They're not pretty. They're messy. They're glitchy.
Yeah, I can't understand why the state or the defense would want a virtual trial. It's insane. Like, just think about the witnesses. Just the witnesses alone. You know, you have a witness showing up on camera. The state ain't there. Prosecutor's not in that room with that witness. The judge is not in the room with that witness. The jury is not in the room with that witness. The jury's watching them on Zoom. The defendant can't see them. The defense lawyer can't see that witness. They can see their face in a box on Zoom. You can't see their body language. You can't, the vocal inflection, the connection for the internet. It's horrible. It is the worst idea in the history of law to have virtual
trials. And even
trials.
when they have them inside an actual courtroom, they'll be wearing these face masks, which for centuries we've had in courts. You can't wear hats, you can't wear facial coverings, but all of a sudden, now we don't want to see your face anymore.
Yeah, we don't want to know when you're lying. We don't want to be able to see it in your face when you're lying anymore. We don't want to know, as an attorney, when I ask you a question, how you're reacting to it because you've got this permanent sang-froid because you have a mask on. It's insane. This is the just death of trials, right? Or of any... And that's just the witnesses. The real problem, the unsung problem here, is the jury. Because just like the witnesses, you have to bring a jury in what's called voir dire, where you examine each of the jurors. You ask them where they work. You ask them, do you know police officers? Do you have any in your family? You ask them, how do you feel about marijuana? Have you ever been convicted of a crime yourself? Do you know any judges? Or are any of them in your family? If a cop came in here and he was dressed in uniform, would you give any special weight to their testimony over, say, somebody who is not in uniform? How are you going to judge their answers realistically if they're not in the room with you? If they're on a Zoom call with 30 other people? It's just not realistic. It's insane to think that you can do a trial by Zoom. So, I don't know, let's see. Accusation speedy in public trial. Yep, that's violated. Where the crime shall have been committed. Yeah, I guess we can save that one. To be informed of the nature and cause of the accusation. Yeah, I guess that still applies during COVID. But be confronted with witnesses against him? No. To have compulsory process for obtaining witnesses in his favor? Not really, because you can subpoena the witnesses, but they're going to show up by Zoom as well. And have the assistance of counsel for his defense. That's being violated too. I mean, they keep lawyers out of the courtroom too when these things are shut down. They keep lawyers out of the jail, if you can believe that, while COVID is going on. Like the Sixth Amendment, they just threw it out the window because of COVID. It's the most incredible thing. And like you were saying, Tiger, when we first brought up the Sixth Amendment, the right to a speedy trial, like they're like, nah, we don't really care about that anymore.
The courts keep saying that that the state has a substantial interest, and so it overrides it. They apply the strict scrutiny test and believe it actually passes. And I don't see it as passing because it still has to be narrowly tailored, and closing down courts, denying your right to speedy trial. How's that narrowly tailored, even if there is a substantial interest?
And it's not just denying you a trial. It's denying you all access to the courts whatsoever. You can't even get in for a hearing, right? Now in Florida, I mean, that's different. We've got, the party state. Everybody goes everywhere now. And all of our hearings are electronic. I'm still hoping when we bring trials back, they will not be virtual. But think about this. The case of Milligan, right? Milligan is a famous constitutional law case. Milligan was an Indiana citizen, and he was a sympathizer for the Southerners in the Civil War. These people straight up kidnapped him out of his house in the middle of the night and put him before a military tribunal for supporting the South. He was convicted. He, filed for habeas corpus with the United States Supreme Court. And the beauty of it is the war was over by the time the Supreme Court heard it. So they could judge it on the law and not on political expediency. And their ruling was that you can't just take someone who's a civilian, by the way, during time of war and put him before a military tribunal. The courts were open. That was the basis of their reasoning. The civil courts were open. And think about that for a second. During the Civil War, the courts were open. There has never been a time in American history where they just shut down all courts in this country simultaneously and just kept them closed indefinitely. That did not happen during the Civil War, the greatest crisis in American history. And yet now they just said, well, the Sixth Amendment doesn't really apply because the state has a compelling interest. Like the states didn't have compelling interests during the Civil War or any of our wars, the war on terror. People would be up in arms if you shut down speedy trials, shut down courts because an airplane got hijacked or because we have terrorists in our midst. But if you say you could get COVID, well, the Constitution no longer applies. So one of the most important parts in the Sixth Amendment, to have the assistance of counsel for his defense. You have a right to a lawyer. If you cannot afford a lawyer, one will be appointed for you. The Sixth Amendment, the importance of it cannot be overemphasized. You have to have a lawyer in a criminal case. They can't just railroad you. Now, some people think that this Sixth Amendment applies, to all court cases, and it just plain doesn't. You do not have a right to a lawyer in a civil case. You don't have the right to a lawyer in a family case, or an eminent domain case, or a contracts case, whatever you want to. This only applies to criminal defense. You have the right to a lawyer, so they will appoint it to you, and the state will pay for it if you can't. If you can't pay for a lawyer in your breach of contract case, that's too bad, Geronimo. Just too bad. You do not have a right to it, and the state will not pay for it. Now,
while we're on there about the rights to a lawyer, I think there's a lot of misunderstanding about the public defender. So when the state, so if you're found to not have enough money to afford your own lawyer, the state will give you either a public defender or some lawyer on call for the jury, for the judge, if there's no public defender's office in the county. And the public defenders, they have a poor reputation as, I think there's a misunderstanding where people think like they're not real lawyers is typically what they say. And they are. They often are extremely zealous advocates for the accused. Like they genuinely believe in their job. And when you're looking at choosing between a public defender or a criminal defense attorney, there's advantages and disadvantages to having either one. A public defender, one of their big advantages for you is that they typically operate in front of the same judge in the same courtroom every single day. And so the judge knows that attorney. And that's a very big advantage because typically that means the judge respects that attorney and that attorney's judgment. If you bring in some criminal defense attorney that the judge is not familiar with, then that it can be good or it can be bad. It's just something to consider. And that's one, but it's a pretty big advantage when the judge knows the attorneys.
Yeah, that's very true. And in a lot of public defender situations, they're with the same judge even for a lot of the time. So I will say, I've had cases all across the country, and going into these places as an outsider is sometimes counterproductive, especially if it's a small town. Now, if it's a place like Boston, there's no problem in Boston if I show up and say, yeah, I'm from Florida. Nobody cares. If I go to New York City, nobody cares that I'm from Florida. They're just like, yeah, well, there's people from foreign states here all the time. Who cares? But if you go to some place like Orlando, if it were in reverse and somebody were coming from outside to Orlando, it's a big city, but it's also a very small town when it comes to the legal profession. Those judges know all of the lawyers that are coming before them. They're not going to miss it when somebody comes in that they don't know. And if you're in a small town, then yeah, you definitely want someone there. Like in York, in South Carolina, in York County, they do not like outsiders there. I can tell you that. They want somebody who they know and who they trust. And yeah, a lot of people talk badly about the public defenders, but I tell you what, I've got two of the greatest public defenders God ever put in America. And I would not hire a private attorney because my public defenders are so good. So, just lawyers are lawyers, man. You've got good lawyers, you've got bad lawyers, you got good public defenders, you got bad public defenders. But like you're saying, Tiger, public defenders are very passionate about their jobs. I've also known criminal defense attorneys who were private attorneys, but who were state attorneys before. They were prosecutors before. Now, some people think that this gives them some kind of an advantage. Like, oh, well, they know those guys. They know how they work. But think of it the other way. They know those guys because they went drinking with them, because they were working in their office together for years, because they are friends with them. And now they are your criminal defense attorney, and they do not want to step on the toes of their own friends. They used to work on that side of the aisle, and now they are your lawyer. So yeah, they might know the inner workings of the prosecutor's office, but they also know the prosecutors, right? And they know the other people in there, and they don't want to get a reputation for fighting with the people that they used to work with. Food for thought. So, we've got 20 minutes left. We better get through the rest of these amendments. Is there anything else we missed, Tiger, on the Sixth Amendment there?
The right to confront witnesses is a very big deal, and that's been trampled over for the past couple years. especially with, they call those kangaroo courts in colleges where a guy's accused of rape, but the girl they won't put on the stand. Yeah, that goes on. And typically, a lot of these victims' rights bills, they will be something like that, where they won't put the child on the stand, or they won't put the woman on the stand because it's traumatizing. They can't be cross-examined.
Yeah, and that's systematic now. That is just all across the board. They do it in the guise of let's protect this victim. Never any consideration of whether that victim is an alleged victim, whether that victim is lying, whether the person accused is falsely accused. That's actually the entire point of the Bill of Rights. That's the entire point of due process. That's the entire point, as you're saying, Tiger, of being able to confront the witnesses. Because if you can't, then an accusation is enough to convict you.
Yeah, and this was one of the fundamental laws of nature, as I like to talk about. Being able to confront your accuser was considered one of those natural rights that people had. And for a long time in America, they were allowed to bring in out-of-court statements, like just about anything, if the witness was not available. And that was due to a Supreme Court ruling in 1980. And it wasn't until Scalia, he completely overruled that with his Crawford ruling, where he reasserted that you have the right to confront your accuser, and that includes these out-of-court statements and unavailable witnesses and things like that. There's still some exceptions now, but it's a lot more strengthened because of Justice Scalia. And
if somebody dies and their dying breath is, Tiger Gin did this, that makes sense, the dying man's declaration. But when you claim, well, this guy's unavailable, but he did say this last year when we talked to him, that doesn't fly. You can't have somebody just say, well, this guy said X, Y, and Z, but we can't find him now. Because you can't confront that person. You can't cross-examine them. You cannot determine the truth of that statement. And that's why they call it hearsay. Because if you can't determine the truth of the matter, then it can't be introduced. There are exceptions to that, but the rules of evidence, we've been developing them for centuries, and thank God for Scalia. Apolitical show, by the way, but thank God for Scalia, who was not a politician. He was a judge, by the way. But he did.
If any judge did that any judge that would have done that is my hero automatically. It's a really big deal.
Yeah, if Kagan had actually defended, the law and the right to confront witnesses and the rules of evidence, I'd praise Kagan. Yeah, sure. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Well, I guess if you shoplifted $5, you're out of luck. In all seriousness, though, you have the right to a trial by jury. That's almost always what you want to do, but again, it's a case-by-case basis. Now, the common wisdom here is that if you are a defense attorney, anyway, all you have to do is convince one person that the state did not even that your client's innocent, not even that your client, nothing. All you have to prove is that the state did not meet its burden of proof. You convince one person of that, and there's no conviction. So it's much easier to do that than to convince a judge. Now, you might be thinking, well, as I've said a million times, jurors can be retarded. Juries are masses of people. It's the roll of the dice, right? Wouldn't I want a judge who is not swayed by emotion, who will actually judge the facts impartially? Wouldn't I want him deciding the case? Wouldn't I want a judge who knows the law and knows all these shady things that the prosecutor is doing? Wouldn't I want them? I want that guy to judge the case. Not a bunch of people I don't know who have no idea what this case is, who, I don't know their intellectual capacity. All I know is what we found out in voir dire and what they filled out on their paper when they came in. You might be thinking that. But there's also to consider the fact that judges are political animals. They have either been appointed or they have been elected, and either way, they didn't do that by not being political. Either you ran for office and you were elected as a judge, or you knew the right people and you were appointed as a judge. So when you get a case where it is just a heinous defendant, a notorious defendant who absolutely cannot walk free, my God, or you as the judge would suffer politically, what are you going to do? And that's the question that every criminal defendant has to answer for himself. What would that judge do? And that is itself a gamble, just like going to the jury is a gamble. You don't know whether the judge is going to be swayed by public opinion, whether the judge is going to say, well, I don't like the state's case, I don't think they proved it, but if I let this guy walk, I'm going to get bricks through my window. You don't think judges are cognizant of that? What was that, the Kyle Rittenhouse hearing? Right?
Yep.
When they were trying to get his address released, to the prosecutor so that they could basically release it to the public. And the judge was like, no, absolutely not. I've had bricks thrown through this courtroom window because of this case. And you think I'm going to believe that if we release this kid's address that they're not going to do the same to him or worse? Obviously, there's a real public safety threat here. So judges know this, man. They're getting bricks through their own windows. So if they let the wrong guy go and it's on him, he might not let that guy go. It's a lot better if the jury lets that guy go because they're completely anonymous, right? At least their decision making is anonymous. They're not allowed to be interviewed. You can't question the jury about their ruling. So they're completely protected. And everybody, the state, the judge, the cops, everybody can say, well, the jury decided it. Not up to us. We did all we could. So, again, it's on a case-by-case basis, but you have the right to a trial by jury.
And I want to be real quick about this. It's regarding the right to trial by jury by both the 6th and 7th. Both were incorporated to the states by the 14th Amendment. Right. The 6th is regarding criminal trials. The 7th is regarding civil. And this right to trial is still being all trodden over in America. They're stamping over it. Like, for example, where I live, there's a magistrate court. The attorneys, they would go. So a magistrate court will typically be these smaller cases, $100, $200 fine or something. The attorneys, they would go in there. They would try and introduce evidence by the rules of civil procedure or something. The court be, the judge will be, this is a criminal court. You can't do that. They try and introduce some procedure through criminal procedure. Oh, this is a civil court. You can't do that. Same court. And they were doing this for decades until some attorneys decided to file suit against the city and state over this and got this magistrate court to finally admit that it's a criminal court. and that criminal law, criminal procedure applies to it. So watch out for that. Whenever you're being fined by the city or state and you go to one of these magistrate courts, make sure that you have your rights.
Thank you for pointing out. I forgot we were talking about the Seventh Amendment. Yeah. Everything I said, if you're listening to the replay of this and you rewind it a minute or two, that's the Sixth Amendment, not the Seventh Amendment. My bad. Thank you for pointing that out, Tiger. So we've got a couple minutes left. Let's go to the Eighth Amendment. Excessive bail. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
$2 million bail for shooting people in a riot, that's okay.
Actually, yeah. I genuinely would actually agree that can be okay. I had it wasn't my case, but I had many cases in front of this judge. She's a misdemeanor judge, not even a felony court. This is a misdemeanor court. So no matter what happens, you cannot go to jail for more than a year. You cannot, I mean, this is Florida, by the way. This is not all states. This is a Florida misdemeanor. It means you can be jailed up to a year, or you have probation up to a year. So no matter what happens, it's going to be less than a year punishment, right? She gave this guy a $1 million bond on a misdemeanor because he mouthed off to her in court. And as unreasonable as that may be, I would have challenged it. The thing is, what are you going to do about it? You going to appeal? How long is that going to take? What are you going to do about getting $1 million bond when you are indigent to begin with and you've been detained on a misdemeanor? And you've mouthed off to the judge. You're kind of screwed. So a lot of things will fly just because they can fly, and nobody's going to question them. As far as cruel and unusual punishments, I guess, if you put them in the Iron Maiden, Bill and Ted style, I guess nobody hangs anybody anymore. But yeah, execution is absolutely not considered cruel and unusual punishment. I don't know. Has anybody actually questioned that cruel and unusual punishment and won? Has anybody been successful on that in recent years? Because
I can't think of any case. I normally see the Eighth Amendment invoked regarding their bond or these suits against the death penalty. Typically, they'll always try and, well, not suits, but the legal activists, they'll call it cruel and unusual punishment, even though, just as we saw in the Fifth Amendment, it says no one shall be deprived of life without due process. Therefore, there can be a proper process to deprive somebody of life.
Right. Death itself is not a cruel and unusual punishment. It's the manner of death. Like it's the electric chair or hanging perhaps, but definitely drawing and quartering. That used to be that you were convicted of treason or some other odious crime. They would tie each of your limbs to a horse and send it in all four directions until you were pulled apart. And the drawing, that's the quartering, because you're cut into four pieces. The drawing was they would cut open your stomach and draw out your intestines. So it was pretty gruesome, these death penalties they used to have.
Well, now that I think about it, there are, the Eighth Amendment gets invoked a lot in prison condition lawsuits. That's where it'll be, and that's where you'll see a lot of victories, where it's over prison conditions.
I see. That makes sense, because those conditions are horrible. Well, we are out of time. Ninth Amendment, The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the fact that you have a right to free speech and a right to due process and the right against searches and seizures, it doesn't mean that those are your only rights, right? In the 10th Amendment, the powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. This amendment is basically done for. It was done for in 1865, and they've just been beating a dead horse ever since. But that's perhaps another conversation for another evening. Tiger, you got any closing thoughts on the Bill of Rights?
Just make sure that whenever you get arrested or even just civil suits, just be on the lookout that's not being trampled on.
True. Well, with that, ladies and gentlemen, I was going to respond to some things in the comments, but there's some kind of lunacy going on in here. Where are our moderators this evening? So anyway, thanks everybody for showing up. And of course, thanks most to my children who are always here and getting educated. And we will see y'all next week. Be there or be square. Good night, everybody.
Take a look at my life and realize there's nothing left. 'Cause I've been blasting and laughing so long that everyone thinks my mind is gone. But I never crossed a man that didn't deserve it. To be treated like a punk, you know that's unheard of. You better watch how you're talking and the way you're walking, 'cause this life alone is legalized in charm. Been spending most of life living in the gangster's paradise. Been spending most of life situation that got me facing. I can't live a normal life. I was raised by the stripe, so I gotta be down with the hood team. It's television watching got me chasing. Death ain't nothing but a heartbeat away. I'm living life to a die.